Law Department. And briefly, I'll mention that our session is being recorded. And like I said, once again, we're glad to have you here joining us today. Just giving a brief summary of what we've done so far. On day one, we did some police officer training, just brief training. And then we had a scenario which ties into the case that we're going to discuss today, and we've been discussing this week. And it was with the McDonald murder trial. And we had a scenario where a suspect came out of a house and police officers had to respond to that suspect on a life-size use of force simulator. And they use a laser gun, and they actually had to confront the person who charged at them with a knife. So that's how day one ended. And they responded to the actual crime, the call for service. Yesterday, Professor Brian Miller came in and he provided a class on latent fingerprint examination. And so he taught everybody how to lift fingerprints from various surfaces. And so he went through that in detail, showed the different types, magnetic fingerprint filament, the regular fingerprint powder, and how to lift the prints and put them on the cards. And then he also talked about this specific case. And this case, and Johnny, Professor Jones, correct me if I'm wrong, but it happened in 1970. And so in 1970, of course, the science and technology was so different, and this case would have been handled completely differently than it is than it would be right now. So we didn't have DNA. The use of DNA wasn't there, and actually I saw a picture that Professor Jones had submitted with Kirk Bloodstreet or Kirk Bloodsworth from Baltimore County, Maryland, who was on death row. He was accused of killing some children up in Baltimore County, and he's the first person who had been on death row to have his case overturned as a result of DNA. When he was arrested and tried, they weren't using DNA yet, and then subsequent to him being in prison, DNA evidence came into play, and he was out, and he's an advocate of eliminating the death penalty. So we talked about this specific case and some of the evidence that was involved. The fact that McDonald, who was a doctor, and he was also a captain in the military, and he was alleged to have stabbed himself, and it was serious. But because he was a doctor, he actually knew where he could put the knife in and not kill himself. But there's a lot of evidence, and some of this we'll talk about today. So Professor Miller went over some of the elements of this specific case and how that evidence would have been secured, lifted. And then, we talked about chain of custody, which I'm sure Professor Jones and Professor Blyer will talk about today. So all of those different things that we utilize. So I'll tell you what we're going to do while we're waiting for that. Professor Jones, if you want, if you can introduce yourself and you can get started with your portion of the presentation, and I will share your PowerPoint when you're ready to do that.
Okay, I'm ready.
Okay. If you can introduce yourself and tell them a little bit about yourself.
Okay, yes, my name is Professor Johnny Jones, and I am in the Public Safety and Law Department, and I am an active practicing attorney along with being a professor. Now, I'm not taking on any cases currently. I do a lot of legal consulting, but I've been a prosecutor for many years. I've been practicing law for over close to 40 years now. But I was a trial attorney also, and I came to Maryland from New Mexico. I'm from the western area of the United States, and I worked in the district attorney's office. I was assistant district attorney's office, and I've handled cases minor petty misdemeanor cases to felony, death penalty cases. It's been a while since I've had a jury trial, so this was an interesting experience because I was kind of treating it like preparing for trial, but I know the evidence is just significant here. And this is a trial that could probably, I'm sure could go on for at least a month or more. I'm not sure how long the actual trial lasted, but when I was in the DA's office, I remember it was about 1987. That's when DNA became acceptable, right around that area, because I do recall that we had some seminars on it. But at the same time, I worked on some felony cases. I know we had an issue yesterday. We talked about duty attorneys, on-duty attorneys. I actually was one of the attorneys that was on duty. This is back west, and there might have been a misunderstanding. But on the weekends, usually, particularly if it's dealing with a violent crime, there's going to be an attorney on call in case there is a issue at the crime scene. I've went to a couple, but I'm not required to come. But this is something that I was discussing earlier with some other states' attorneys. But in any event, I'm just going to go over just the just trial procedure, particularly on how a paralegal or legal assistant can help. And I'll just use this PowerPoint presentation just to go through each of the the most important aspects of preparing and trial procedure.
And Johnny, if you can go to share screen and allow other people to share.
Okay.
Nope.
I'm on.
Nope. Turn off, go up to the top and hit the green button again. Turn off the share screen. Or there you go. Johnny, if you can go to the green button and when on the arrow up where it says allow other participants to share, just highlight
Okay.
that. Okay, I'm good. I'm good now. I'm pulling it up, Johnny.
Okay.
Percy, can you hear us in here? Percy, can you hear us?
I can hear you.
Oh, okay,
Yes.
can you make Terry a co-host?
I can't. Johnny has to do that. And Johnny, if you can make me a co-host as well.
Okay.
Okay. I'm trying to find where to make you a co-host. Let me.
Go to
Just
the-
under participants. Go to participants and then there will be menu like more. You'll see an option to make them co-hosts.
No, that was me.
Click on
Do
participants.
you see that, Johnny?
Attorney,
Yes.
attorney.
It's Terry's a co-host now.
Great. Now she can share
Okay.
Okay.
when she's
So
ready.
I'm going to do it right now. So, all right. Thank you. Johnny, if you want to keep going,
Okay.
just let me know when you're ready.
All right.
The
Go
video,
ahead.
change the video to change the video
That's.
to like the second middle
And-
one.
want,
If you
Unless
can
you want
mute,
to show them.
if you can mute Eric, Laura. Thank you. All right. Go ahead, Johnny.
Okay. And you can continue. Okay. And again, this is when you're in trial, you're dealing with litigation, and as I said, litigation is expensive, both civil and criminal, and trials as they are costly and very time consuming, both civil and criminal, and sometimes we as prosecutors have to make a decision on whether to, I mean, we do take costs in consideration in pursuing a case. And certainly if it's a high profile case, homicide, we will move forward. But if you can resolve the case, and if it's civil, it's via a settlement. But if it's criminal, it's using a plea agreement to try to settle the matter. But if you can't settle it, then we have to prepare and go to trial. You can click on, I think there's more underneath. Now, there's alternative dispute resolution, and you have that both in civil, you also have it in criminal. I've had cases that I've referred, especially like misdemeanor cases, or the judges asked if the case can be referred to mediation to see whether or not it can be resolved. And if it can, that's great, because it takes the load off of the judge and off of the court. So ADR is very important in both civil and also criminal, if we can resolve the matter and free up the judge's time so he can proceed with his docket, his busy docket, because the court is very full right now, especially with the COVID-19 health crisis. I mean, cases are backlogged, and these judges want to move these cases. So if it can't be resolved through a settlement or plea agreement, then we move forward, and then we start to proceed to trial. And then now it's time to prepare. The next slide. And you click it again. Okay. Yeah, it's moving kind of slow. Now, in trial preparation, and this is where the paralegal is going to be very important, and my legal assistant will be working together in preparing, this case. I use what's called a trial notebook. The old, a lot of old attorneys, they use case files, but I think a trial notebook is probably the best use in preparing a lot of the important documents. And via a laptop computer or notebook. But I always like to have a manual trial book in case electricity goes down, to be ready to proceed forward. So I would create a manual trial notebook, and I'll use a 3-ring binder, and I'll have within that notebook a copy of all my pleadings, the interrogatories, that's more civil, and deposition, transcripts, but you can take depositions in criminal cases also. And what that's going to be used for is to impeach. And then pretrial motions, any motions I have, it will be in a notebook. Voir dire questions, these are questions that I'm going to be used in order to see if we, to pick a fair and impartial jury. And then a witness list, with the questions. Yeah, and again, the paralegal legal assistant is assisting me with this list of exhibits, getting the exhibits ordered, and also an exhibit chart, and then have a rule of evidence chart guide. All of this is inside the trial notebook. And then motions in limine, we'll have that. And motions in limine is basically to try to decide issues before we begin picking the jury, try to decide matters, before we head to trial. Like, for example, if I want to put a witness on that maybe have an old conviction, the federal rules say 10 years. Yeah, it should not. If someone has a conviction of 10 years, it could be used, but I want to get that resolved. So if I was a defense attorney, I certainly, if I want to put this witness on, I don't want the prosecutor talking about or bringing up an old conviction. But this is something that will have to be handled in chambers in front of the judge, and there'll be a court reporter, and the defendant will be there if it's a criminal trial, and then any additional documents, information. And so this is the trial notebook. I don't know if you can see it. I can't put a lot of the evidence. You can see this is what a notebook looks like. I know this is, but it's just a standard 3-ring binder, ready to proceed. All right, next slide. So this is going to be important for my paralegal. And in many cases, I've had paralegals who are also investigators. But when I was working as a prosecutor, we had a separate investigation office, and we also had paralegals. But it's important to start, put our witness list together and then start contacting our witnesses and to issue subpoenas to all witnesses. And this is important because this is a duty of competence for attorneys, to subpoena all witnesses. And then whether I'm going to use them all, I'll have to interview them, and that will be done during a witness preparation, decide whether or not they'll make a good witness if I put them on the stand. And we can do some role playing. I can't tell a witness what to say, but I want to at least prepare them, especially if it's a high profile case, a homicide case. I want that witness, the witnesses to get relaxed, maybe even go into the courtroom, particularly if it's children, involved. Now, as far as exhibits and displays, preparation, again, the paralegal legal assistant will assist in gathering the photographs, maps, charts, diagrams that we need, copies of original documents, and then, setting up any, if we need easels are kind of outdated now, but they could still be used, and PowerPoint presentations if necessary, and then update the trial notebook as we go. Next slide.
Johnny, if I can just add in, one of the things, as you're talking about witnesses and things like that and the evidence and case preparation, one of the largest cases, biggest cases that we've ever seen was the OJ case. And
Right.
you never ask a question that you don't know the answer to. You should know the answer to that question you're going to ask. And as Johnny said, as Professor Jones said, he's not giving the answer or telling them what to say, but we want to know what that person's going to say. But also think about it. When they had OJ put on that glove, they didn't know that glove would not fit. And that was one of those nails in the coffin that killed their case.
Yeah, that was a major mistake that was made by Chris Darden.
Absolutely.
Anyway, yeah. Now we'll have a pretrial conference, and what the pretrial conference is, this is where the attorneys will meet and the defendant, the criminal case, to see, once again, the judge is trying to see whether we can resolve this matter. And if we can't resolve it, again, the court has rules that the attorneys need to abide by, and then we can address any motions and limines at that time in chambers, and then also any trial procedures and chamber rules. And every judge is different, so you need to know what that judge's particular rules are in his or her courtroom. So that's important. So if it can't be resolved through the pre-trial conference, once again, the rules are set forth, and then we move forward. Now we go to jury selection. And jury selection, we call this voir dire or voir dire. And once again, I have, again, I couldn't load these. I don't know if y'all can see them. These are some of my old jury surveys that I will review. Both sides, both the prosecution and the defense will review these surveys. And just to give you an example, just some of the questions they'll ask the name, the age, and can you read, write, speak, and understand English language, and then your marital status, whether you're single, married, widowed, your grade level, spouse, if you do have a spouse, occupation, and employer. And I'm looking at one other. Have you or a member of your immediate family ever been involved in either a civil or criminal case? And it says, if yes, please date, location, type of case, extent of involvement, or no. And again, then below, your response to the following question is optional. What is your, again, this is optional. What is your race, sex, age? And I guess with the new, whether, transgender, that could be another part. Again, this is this is some of my old jury surveys. And again, it gives us basic information to kind of help us prepare for the voir dire questions. And once again, this is what it looks like. And I got to be careful because there's confidential information on here that I shouldn't be sharing, that I can't share online because it has some sensitive information. So I'm going to review the jury surveys before we start the voir dire and then develop a jury profile. Yes, we develop a jury profile and we develop voir dire questions to uncover bias and to give you an idea of what some voir dire questions are. And every jurisdiction, it kind of differs. The judge may do the questioning, where the attorneys will submit their questions to the judge. And then some jurisdictions, the attorneys will do the questioning. I'm looking at one case right now where this is actually a case, this was in the Superior Court in the District of Columbia. I don't know if you can see it. These are my actual voir dire questions where I had to submit it to the judge. And basically this was a felony case. And my client in this particular case, he was charged with trafficking, which is a very serious offense in DC. And so here's some questions that I have for voir dire. And once again, voir dire means to speak the truth. Voir dire, the whole purpose of voir dire is trying to pick a fair and impartial jury. But I'm going to be very honest with you. If I'm the prosecution or if in a civil case, I don't want a fair and impartial jury. I want a jury that's going to side with me. If I can, both sides are going to be that way. So here's a question. This is a question just to give you an idea. Does anyone have any medical or personal reasons that would prevent them from sitting as a juror in this case and giving their full attention to all proceedings? Again, we're just waiting, to see if anyone responds. Because if that's an issue, then I'll go into that juror in a little more detail about whether this will be a problem. And if so, I might want to try to get rid of that juror for cause and not use my peremptory challenges, which you see below, but I'll keep going. Once again, here's another question. In fact, I'll read what my client was charged with. The indictment in this case charges unlawful distribution of a controlled substance, cocaine. In view of these charges, is there anyone who would be at all unable to fairly evaluate the evidence as presented in court involving my client without regard to the particular nature of these charges? And then, is anyone familiar with the area of, again, this is 4th Street, Florida Avenue, Washington, D.C. And I'll just move through. Has anyone heard of any publicity concerning this case? If so, what, when? Is there anyone who would tend to believe or disbelieve the testimony of a police officer simply based on his or her occupation, etc.? And again, we're just listening to these responses of these jurors. And certainly if I'm a prosecutor, if I feel that a juror is going to be biased, particularly against law enforcement officers or had a bad experience with a law enforcement officer, I don't want that juror on my, on the panel. I'm going to strike that juror. Now, as a defense attorney, I would want that juror. But now we get down to the issues of challenges during voir dire. Now you see these challenges. We have now challenges for cause is unlimited. So if I can get that juror off, if I'm a prosecutor and I have a juror that has an issue with the police, I'm going to try to find a way to get that juror off for cause. If I can't get that juror off for cause, then I'm going to use my peremptory challenge to strike them. And I can strike any juror so long as it's not based on race, gender, or any illegal or prohibited, acts that violate the Constitution. So I want to save my peremptory challenge and use them last. But once again, I get a certain number. Once I use them up, that's it. Okay. But challenges for cause is unlimited. Now, alternate jurors will be selected, and usually they don't know they're an alternate. And you got to look at your jurisdiction. Some jurisdictions will dismiss their alternate jurors after closing arguments, jury instructions. Some jurisdictions will keep the alternate until the jury comes to a verdict. I like that because anything can happen in that jury room. And then, you know, if we've dismissed the alternates before deliberation and a juror has a problem during deliberation, then this trial may need to be tried again. And we don't want that result. I know in California, they keep their alternates, okay, until the jury has, you know, come up with a decision. All right, next slide.
Johnny, if I can real quick,
Sure.
a case, this is a case involving me as a police officer. Me and a partner were being sued, and we're in court in Baltimore. And they brought in the jury pool for the voir dire. And one of the questions was, do any of you, and there was at the time, you know, they brought in different panels, I want to say like 75 people. They brought them into the courtroom, a huge courtroom, and asked, do
Yeah.
any of you know these police officers? And this little old woman stood up and she said, I think I know that officer. And it was my partner. I won't say his name, but my partner. And she says, and they asked what happened. And she said, one night I got a flat tire on the Beltway and it was raining. And this officer stopped and changed my tire. So
Yeah.
what that did was taint that jury in the panel, at least in our favor, going, man, these must be some really good guys for them to stop in the rain and change a woman's tire. So
Yeah.
things like that can happen. Once again, no control over what those answers are going to be. And you never know what could happen there. So that was
You're
awesome.
absolutely right. And you better believe the defense attorney is going to want to strike her.
Oh yeah, absolutely. But the damage was already done.
Exactly.
Okay, let me get back here.
Now, once we have a jury, once a jury's been selected, you know, the jury's sworn. Once the jury's sworn, double jeopardy attaches. Okay. So which means if there's a verdict at the end, you can't try this defendant twice. So jeopardy attaches once that juror is sworn in. And then we'll begin opening statements. And opening statements, basically, as I have here, is just a roadmap. The plaintiff goes first and the defendant next if he or she so chooses. Now, I usually tell young attorneys, and you know, if the prosecution opens, you ought to open as a defense attorney, okay? But the defense attorney could wait until their case in chief and make their opening, but that's a strategical area that they'll have to decide. It's rare, but I've seen it done before. So opening statements, once again, it's important. The jury tend to pay attention to two main areas of the trial. They pay attention to the opening statements and they pay attention to the closing statements. Everything in the middle, you know, it's important, but the opening statements, a lot of times jurors will make up their mind at opening statements and certainly at closing statements. So opening statements is important, but it can be waived by both sides. Both sides can waive and just proceed with their case in chief. Now, once again, opening statements is where attorneys give a brief version or overview of the facts and the supporting evidence for their case. And then once again, I always tell attorneys, always start with the evidence will show, and that will help, you know, prevent an objection to the opening statement as argument. So always at the beginning, the evidence will show. Okay, next slide. All right, now it's time to present our case. Now, how do we present our case? The plaintiff presents their case through what's called direct examination, and the defense presents their defense through what's called direct examination, okay? And then cross-examination where the opponent has an opportunity to attack the evidence or the witness in the case. Now, so the plaintiff goes first, and when it comes to criminal cases, you know, the prosecutor or state's attorney has the first and last say. Why? Because the standard of proof is higher in a criminal case. It's beyond a reasonable doubt. Now, in a civil case, it's preponderance of the evidence. And in a civil case, the petitioner goes first and then the defendant last. But in a criminal case, the prosecution will have the first and last say in the case. But anyway, going to presenting the case through direct examination. So the prosecutor is going to present their case through direct examination by presenting the evidence, you know, the the important evidence through testimony, photographs, documents, diagrams, displays, and the legal assistant or paralegal will be present to assist and help with the organization of this. Now, once I present my case or present a witness or evidence, then the defense will have a chance to cross-examine it, by using leading questions. Now, let me go back to direct examination because it's a little confusing here. Now, leading questions are prohibited on direct examination, whether it's the plaintiff or the defense, okay? You can't use leading questions. And once here, I have an exception below. Now, if I have a young child or a hostile witness, or maybe a witness that's competent but has some mental issues, I may need to approach the bench and ask the judge if I could use leading questions in my direct examination if in the plaintiff's case. So, and then the defense certainly has cross-examination by using leading questions, basically to tear down the prosecutor's case. And then the prosecutor or the plaintiff can use redirect examination to rehabilitate the witness that's on the stand. And then there could be recross examination, then could be redirect, recross. Where does it stop? The judge is going to stop it. Okay, next slide. Now, once the plaintiff finished presenting the case, they rest. And at this point, the defense should stand up. The defense attorney should be making objections to controversial, evidentiary matters throughout the trial. But once the prosecutor rests, there's going to be a motion for directed verdict. And again, this is where the directed verdict is going to test the indictment or the information. And the defense need to make this motion in order to reserve their objections for appeal. So it's always raised by the defense to preserve the appeal rights for the trial rulings on objections. And the motion for a directed verdict is seldom granted, especially in a jury trial. It's significant and have genuine facts. And the judge is going to move to deny the defense's motion and is going to move forward. But it's possible the judge could, if it's a multiple count indictment, there could be certain counts that could be dismissed. Other counts, the judge will deny the motion, or the judge could dismiss the whole case. If the judge dismissed the whole case, it's over. But as I said, with the high profile case, it's rare because judges prefer that case to go to the jury. Okay, and so once the directed verdict is denied or by the judge, then it's the defense's opportunity to present their defense. Next slide. Now at this time, the defense is going to present, the defendant is going to present their defense through what's called direct examination. This is their defense. But before they proceed, if they have not made an opening statement, they can do it at this time, or they can waive it and proceed forward. So the defense will present their defense through direct examination by presentation of evidence through testimony, photographs, documents, diagrams, experts, etc. And then once again, leading questions cannot be used in direct examination, with the exception for young children or hostile witnesses. Okay, and there was one other point I wanted to make on this, but anyway, we'll move forward. Now, the plaintiff or the prosecution has a right to cross-examine through leading questions. And some of you might say, well, what are leading questions? You basically the questions that are suggesting the answer. You can't use that on direct examination. So I tell attorneys, if one way to avoid having objection to leading questions, use when, what, where, why on direct examination. And then for cross-examination, you use leading questions, you suggest the answer, to the witness, and also you're presenting your theory of the case through leading questions. Now, again, the plaintiff once again can cross-examine, and then the defense, can redirect after cross-examination. Plaintiff can recross, and then the judge is going to cut it off. All right, next slide.
Professor Jones, I'm not sure further in the presentation, but can you explain what a rule on witnesses is?
Well, if I'm understanding you right, usually I will raise the rule, where I don't want witnesses to hear the testimony, so I'll ask them to step out. Is that what you're referring to?
Yeah, yes.
Yeah. Now certainly, if now I'll use, as a prosecutor, I'll have the lead police officer, detective sit at the table with me, because I have a right to have the government has a right to have assistance, with the case. So that lead detective will be able to stay in, but the rest of the witnesses will have to remain outside the courtroom, and they're instructed not to talk about the case at that point. So we call it invoking the rule, and I think that's important. So now only exception to that, Percy, would be experts. An expert could sit in on the case. All right. The next slide. So once defense rests, the defense is going to be moving to dismiss. The defense is going to be trying to dismiss this criminal case throughout the trial. And, the judge at that point could dismiss it, but normally, if it's a jury trial, the judge is going to let it proceed to the jury if there are legitimate factual issues at dispute. Now, once the defense rests, now the prosecution may or may not present a rebuttal case. And they did that in the OJ case. They did present a rebuttal case. Or the prosecution could choose just to go to closing arguments and jury instruction. But a rebuttal case is where the prosecution has an opportunity to rebut the defense's case in chief. All right, and the plaintiff is permitted to offer evidence to rebut. And once again, the defense may present rebuttal to the plaintiff's rebuttal, if that makes sense. And then the judge is going to cut it off. Okay, but a rebuttal case, that's a tactical decision that the prosecution is going to have to make, whether they want to present a rebuttal case to the defense's case. If not, next slide will go to closing arguments. And once again, the plaintiff is first and the defense is last in the civil case, as I pointed out. And in the criminal case, the plaintiff is the first and last. And the reason why in the criminal case is the prosecutor has a higher burden of proof, got to prove the case beyond a reasonable doubt. And, beyond a reasonable doubt, it's not, it doesn't have to be 100%. I mean, if you look at a scale, that scale's got to be tipped somewhere in the 90-95 percentile in order to get a conviction. It doesn't have to be 100%, but in that area. So once again, the basically what happens in closing arguments is the attorney summarize the presentations and argue in favor of their client, and it's a prosecutor will be arguing in favor of the state and moving for a conviction. And then the closing argument should include all of the major points that support the client's case and the shortcomings of the opposing party case. And then we go to jury instructions. Okay, now you got to look at some jurisdictions. Some jurisdictions will they'll do jury instructions first and then closing arguments last. But again, look at your particular jurisdiction for the jury instructions. And I have jury instructions here. I don't know if you can see it. This is actually these are criminal jury instructions that I have, and these are some of my these are some actual jury instructions that I've used in trial, where the judge is going to read the law to the jury, and basically if the jury makes certain factual findings, then they need to apply the law pursuant to those jury instructions. Okay, next slide. And then once again, after the jury instructions, the jury will deliberate. Okay. Now at this point, once again, some jurisdictions, they'll dismiss the alternate jurors before the jury goes in for deliberation. Other jurisdictions will hold on to the alternates until a verdict is entered. And I think that's more of the favored way to go. So what is a verdict? So a jury issues a verdict in favor of one of the parties, and it's either going to be guilty or not guilty, or the jury can hang. You know, otherwise hang means, or a hung jury means the jury can't come to a decision. But the judge is going to try, you know, to encourage them to go back in and try to reach a decision. But if the jury is hopelessly deadlocked, then the defense, I'm going to be, if I'm a defense attorney, I'm going to be moving for a mistrial, and the case will be allowed to be retried. You know, even though double jeopardy attached, a verdict was not entered. So therefore the case can be tried again. But once a verdict is entered, you know, then double jeopardy will attach at that point. So once again, when you hear a mistrial or hung jury, in Bill Cosby's case, his first case, it was a hung jury. But because his case was such a high profile case, you know, they retried it again, and you know what the result was. And I thought Bill Cosby had some pretty good appeal issues. And as you see, he won on appeal. He did do time, but he ultimately won his appeal. So if this makes sense. And then once again, the plaintiff or the government in a criminal case is allowed a new trial if a jury hangs or judge declares a mistrial. I'm just highlighting that. And again, jeopardy has not attached because no verdict has been entered. And then the prosecution is going to have, as I said before, the prosecution will have to make a decision on whether to retry the case, because you know, jury trials are time consuming, once again, expensive, as I pointed out at the beginning of the PowerPoint presentation. And they'll have to make a decision on whether to go forward. I know I had a case back west where a prosecutor, I was a special prosecutor on a case with actually involved the prosecutor in another jurisdiction who had left the state's attorney's office, but apparently he had a marital dispute. And anyway, police were called out, and his wife, I believe, was arrested. And I'm not sure if that was the reason why he left the state's attorney's office. But the family members didn't like that. And to make a long story short, he claimed that one of the family members, this is the prosecutor, claimed that one of the family members tried to run him over with the car. But the evidence was shaky, very, very, very shaky. But because this prosecutor was, the former prosecutor was known throughout the DA's office, they asked for a special prosecutor to step in. So I stepped in and took the case, and I was kind of shocked because I thought it was going to get dismissed because it wasn't a very strong case. But he assisted me with it. And anyway, the end result was the jury hung. And then I had, the powers to be, the state's attorney of the jurisdiction had to make a decision whether to retry this case. And we felt it was just too expensive because I spent 2 weeks. This is a 2-week jury trial. And so we weren't going to come back and retry it again. So these are issues that can happen. Okay, the next slide. And then post-trial motions and procedure, if a verdict is entered, well, this is motion for judgment notwithstanding the verdict, or a motion for judgment as a matter of law. Actually, I'm looking at this pre-trial motion and procedure. This would come after, this PowerPoint must be out of place. An MJOA is made after, well, I'm looking at this. Well, you have the defense will be making a motion to dismiss at the end of the case. And okay, so if a verdict is, if a jury finds the defendant guilty, basically what this means, motion for judgment is a matter of law. The defense can request the judge to dismiss the jury verdict. Otherwise, the judge will sit like a 13th juror. And basically you're arguing that the jury verdict is not based on the evidence, because this is a motion, is a judgment, a matter of law. But this is rare. Judges rarely will grant this motion, but it's possible. And the judge could dismiss the case despite the jury verdict. A lot of times the judge would rather this case to go up on appeal. But if the defendant is found not guilty, the case is over. The case is over. But once again, the defendant is found guilty, the defense can challenge the jury verdict, and the motion should be filed within 10 days after entry of the judgment. And then you have a motion under Rule 50 on the rules of, this is more civil procedure or criminal procedure. You're requesting a motion for a new trial, but it's going to have to be some very serious problems or allegations, and some serious problems would be jury misconduct. And one thing I mentioned, if a jury does come back with the verdict, as a defense attorney, I want the jury polled, because there could have been some issues inside that jury room, and I want to speak to the jury if a verdict was entered into against my client, if I was a defense attorney. But once again, you can ask for a new trial if there's jury misconduct or prejudicial jury instructions or excessive inadequate damages. This is more of a civil matter. So you do have a request, you can make a request for a motion for a new trial. All right, next slide. Now, once again, if the defendant loses or if a party loses, then they can appeal, okay? So when it comes to the verdict, there's no new trial or evidence presented at the appellate level. If there isn't, if the defendant loses the case or plaintiff loses the case in a civil case, they can appeal. You can always appeal. And again, there won't be any new trial. And what happens in the appellate courts, they're reviewing courts. And I've had some cases on appeal where paralegals and assistants have assisted me, and all you're doing, you're arguing that there was that the judge or the jury or there were errors in the trial. And once again, if you do file for an appeal, you're gonna submit what's called a notice of appeal to the clerk to send the transcripts up to the appellate court. And once again, the appellate court will review the transcript and also allow you to submit briefs, and they will hold oral arguments so you can argue where substantial errors were made in the trial. Because I can tell you, ladies and gentlemen, there are mistakes that are made in trial. There's no such thing as a perfect trial. There are going to be mistakes made, but is it a mistake that causes substantial prejudice to the plaintiff or the defendant? If it's just plain error, the court is going to, is not going to reverse the decision. But the appellate court could do several things: could confirm the decision, reverse, or remand with instructions. Okay. Next slide. And if you don't like, if there's an intermediate appellate court, you can appeal to a higher court. And once again, you got paralegals and paralegal assistants that assist with appellate attorneys. I know in criminal cases, especially in the state's attorney's office, usually the attorney general will take up cases on appeal, or if it's a, I'm just looking at this other. Now, this enforcement of the judgment, this applies mainly to civil, to a civil case. So we won't go into detail on that because this is mainly a criminal matter. All right. But once again, paralegal assistants are important, and they assist attorneys throughout the trial procedures. Okay, I believe that ends the presentation. And then any questions? As you can see, trial preparation It takes time, it's tedious, and it's important that the legal assistants, paralegals, the investigators, the police, they're all very important in helping to put this case together. All right, thank you.
I didn't know if I should raise my hand or not, but I had a light question, just a lighthearted, but had to do with the subject. Has there ever been like a TV show or a movie court that you've seen that's like accurate to what it's actually like to prepare for the court?
No, no. Hollywood is different from what happens in the courtroom, okay? But you know what? You know, we attorneys, both public defenders and prosecutors, we have, as part of trial preparation, we actually have actors from Hollywood come in and help us, you know, in our presentation of the case, because presence is real important. And there's a lot of acting that goes on in a trial. And so if that answers your questions, I mean, I've actually been in trial seminars where we have brought in movie stars to come in and teach us to have a better presence, you know, in the courtroom, because your presence is very important, just as important as your preparation of the case and how you present yourself. And I'm talking about your dress, speech, manner, being courteous to all the parties. So I hope that makes sense.
Khalil, I know it's hard to understand, but back when I was a narcotics officer, I had a jerry curl and long black beard and earrings. And so when I used to go into court sometimes on a case coming from the street, I would wear the clothes that I would wear on the street, and I'd apologize to the judge and the jury, but it made me look more believable because they would say, oh, wow, I could see him buying drugs or selling drugs in an undercover capacity. So yeah, it's image. A lot of times the jury doesn't like the prosecutor or doesn't like the defense attorney because of the way they look or the way they talk or the way they move. So all those things come into play. Absolutely. Well, look,
exactly.
We're going to take
you see me now, you see my hair, I'll be in the barber. I had to cut it off before I go into a jury.
So look, we're going to take a quick break. It's about almost 2:55 right now. If there's no other questions, we're going to come back at 3:15 for the second portion of the session, and Professor Blyer will jump in. Professor Jones, thank you so far, but I know you'll still be with us, and we'll have some input as we move forward. So we're going to take a quick break, and we'll see you back here at 3:15. Thank you, everybody.
Yeah, thank you. I thank all of you for being present. Okay. And you see snow on the ground. What would you conclude, Henry?
It's snow.
Yeah, but you didn't see it snow.
No, I didn't.
How do you know it snowed?
Well, we
Yeah.
all live our lives with inferences, right?
Yeah.
Thank goodness we don't all have to experience everything, or we
Yeah.
never move forward as anybody.
But
So
certainly I like direct evidence over.
if you have some, that's great, okay?
Yeah. Okay,
But
sorry. Karen.
we'll see. We'll see. No, that's fine. No, thanks, John. We're going to see the one witness here who says she was a witness. She's not the most direct or credible witness in the world when we get there. But mostly we have this really great forensic evidence that Brian told us about. Another thing you'd look at if you were preparing a case, either as the lawyer or the paralegal. And I, when I was in law school, worked my way through. I was working for different litigation firms. They didn't call me a paralegal, but that's pretty much what I was. And the cases I liked best were the ones that I got to follow through right from the beginning to the end. You just feel like you're important and you're doing something. So where would this case be brought, and what are the charges going to be if you are the prosecutor? It wound up in federal court. You know, most cases are state court cases. How come this one is in federal court? Anybody know? We've already talked about what the trigger is for the federal jurisdiction here. Exactly, federal property, okay, a federal base. So federal law is going to govern. And what you can do here when you're looking at the charges you're going to bring from the prosecutor's point of view, federal law here is really pretty much what law in general is. And you'll see that there are 4 kinds of homicide under federal law, pretty typical, right? Start with second-degree murder, assume it's a second-degree murder with malice. Kick it up to first degree if you can show what? It's in the mind of the killer. Premeditation. We think our worst killers are our cold-blooded ones that sat around and waited and thought about it and did it anyway, okay? So there's first-degree murder and there's second-degree murder in the federal system. And you'll see if it's first degree, you get life, okay? If it's second degree, you get any, what does it say here? Any term of years for life, very broad, anywhere for second degree murder. The other kind of homicide is manslaughter. And the federal courts say we got 2 kinds of manslaughter. One is if you were angry, right? Something really, suddenly got you hot-blooded. That knocks the degree of the homicide down only to 15 years. And the other is involuntary, where you usually have an accident. Maybe you were fooling around with a gun or something and it went off, and that's 8 years. So the first question I had for you guys, with the Jeff McDonald killing, if you think he killed his daughters and his wife in that way, what are you going to charge him with? Anybody in the chat? Good. Let me see.
Percy's monitoring the chat.
Okay, Percy's looking at the chat for me.
Yep.
Premeditated,
Okay.
First degree.
Anybody?
premeditated is what I was thinking.
Premeditated. Okay, so
Mhm.
premeditated, that's going to be the first degree, and that's what they charge. Okay,
Mhm.
that makes sense, doesn't it?
Yes.
I mean, he went into the bedrooms, whoever it was, went to those bedrooms and took the club and took the knife, and it probably didn't happen right away, right? Probably took some
And-
time, do all that. So
And
first,
did, and does that involve the death penalty at that time, Terry? I think it did.
in this case, it did not. They didn't charge him with a death penalty offense. I don't know why, Johnny. I didn't look at that.
Yeah.
But
That's what I would have charged him with. I would
No.
charge him with the capital offense.
it was not charged capitally, but so his, the max he could have gotten was life in prison, which is what he wound up getting, ×3. Okay. Someone else mentioned this, I think it was Professor Miller, asked, well, what about the baby? Colette was 4.5 months, I think about halfway, almost exactly halfway around. And you might wonder, is there another charge to be made because of the little boy who never got to draw his first breath?
There's laws now for that, but we probably didn't have laws.
That's right. We do have laws now called feticide. The law at the time, if you look at the murder statute, it says you have to kill a human being. And the courts are very specific about when human life begins, kind of old fashioned and almost literary, but you begin life with your first breath. You've all heard the breath of life, right? And so if the fetus didn't have air in its lungs, if it never drew breath, it wouldn't be considered a feticide. And yeah, I have that. There is a feticide law now that's in the federal government. I had to look it up, but the year it was enacted was 2004.
Yeah.
So when Jeffrey McDonald was on trial, we've got 3 homicide charges for Colette, Kristen, and Kimmy, but nothing for the baby. So that part I think is kind of interesting. And if you want to be a paralegal, a law clerk, go to law school, it's kind of interesting. You can look at your case, see what the statute requires, know what you're going to have to prove. Okay. If you're going to try and get him for first degree murder, you've got to prove premeditation. So you've added that to your slate. Okay. All right. So how are we going to prove that? In the real case, the actual case, this was a 2-month-long case with over 780 exhibits. We're not going to do that. Okay. Hey, we're not going to do that. But you do want to pick up your, think about if you're the prosecutor, who are the people you're going to need to have, maybe by function, if not by name, to prove that case. And this is the way I would do it. I would always start, this is just, it's a technique. When you have a victim, start with somebody who knew that victim and who could make her come alive for the jury. Start with a relative of Colette's. Her mom was still alive when this case was tried. She was her mom's only daughter, and given her mom's only grandchildren. And so her mom would be a great person, I think, to start with. So if one of you come tomorrow, you can play Colette's mom, okay? And one of the things, if you take an evidence class, you have testimony. You can also put in physical evidence, like tangible evidence, documents that include photos, email records, forensic evidence, and things called demonstrative evidence that helps the jury kind of figure it all out. But let's say we're going to do here Colette's mom. What might she want to show the jury while she's there, other than her talking? Could you give her something maybe to show what Colette was like? That you can say to the jury, look at this. Here's my beautiful daughter. Don't people carry pictures around in their wallets when their grandmas? So a picture from that might be exhibit 1 for the prosecution. Okay, just something you can give to the jury, and they do get to take that back with them when they deliberate, you know. So they're gonna get to see it, okay? When I try to tell a story, I always kind of do it beginning to end, you know, once upon a time. It's just the way we're used to hearing things, beginning to end. So I would call the first responder. Of course, there are multiple people, but for this trial, we're going to make a composite first responder guy. And he's the one who gets the 9/11 call and who comes to find the scene. So he'll testify next. And he'll have a lot of exhibits, right? He'll have all the crime scene photos that he can show. He'll have the knife that we had out here yesterday, things like that. Then we had the 3 people who were killed and Dr. McDonald, who went to the hospital. He was out of it, he was unconscious. He had some injuries, but they weren't real serious. So I thought the doctor or coroner would be a good person to say, here's what happened to him. And oh my gosh, here's what happened to them. Okay, which is a big deal. In this case, there were weapons that were found that were consistent with the wounds. Okay, 2 knives, an ice pick, and a club, like a club that had been used to stir paint and fix up a closet. Okay, those weapons were all from inside the house. So if it was hippies, they weren't very smart hippies, right? They went out to kill somebody and they forgot to take their weapons. Okay, or they thought maybe they could find their weapons there. Okay, so these weapons were found outside the house, wiped clean, thrown under a bush. And the night of the killing, like it was a dark and stormy night. It really was. It was raining. So part of the prosecution's case was those weapons that came from the house, that tends to show in their eyes guilt. And they had a babysitter who had been there, you know, every she would take care of the kids while Colette took a class. And she was willing to say, yep, that's the knife I used to cut up their hot dogs. I know because of the marks on it. It's a free knife or something. That's the ice pick. They had a broken ice machine. I had to use that when I want to get ice out. And that club, I saw that in the back where they were working on Kim's closet. So you have a question?
Yeah, so, okay,
Mhm.
if it was multiple weapons,
Uh-huh.
would a jury be more likely to conclude that it was multiple people instead of one person, because one person would more than likely use
One weapon. Yeah. Do you guys agree with that? That the multiple weapons kind of leads people to think, oh, it must have been more than one person?
No,
Okay. You don't think so, Henry? No? How come?
maybe because from my experience as a police officer.
Have you seen one person use multiple weapons?
Yeah.
to kill people?
Yes, but, yes, I mean,
Yeah.
who knows, a weapon could fail, you want to show a different pattern, so.
Exactly. And that's interesting. That both of you guys came up with different angles on that. Yeah, I think it does tend to show multiple people. Just, I don't have any experience. But when Henry talked about his experience, you're saying the guy might have fixed it up that way, right?
Correct.
I want to make it look like it was somebody more than me. And my brain is thinking, Dr. McDonald is a smart guy, right? I'll just use these multiple weapons. I'll overkill. Not because I really hate my kids, but I've decided to kill them anyway. So I might as well make it look good, right?
Right.
So there's 2 ways of looking at that. And it's interesting what the jury does with it. If you all were in the jury deliberation room, you'd have to talk about that and come to some conclusion on that. But the babysitter might be a good kind of almost a throwaway witness to say, yep, these were the things that were in the home. And then our crime scene investigator, the bulk of this case is going to be the crime scene and how we put that together. So Brian Miller, would take the stand and he would talk about all the stuff that he found and how he found it and how he took care of it and what the reasonable inferences from that are. So those would be our witnesses that we'd subpoena. Paralegals, those of you in the paralegal program, what do paralegals do? Professor Jones talked about this. They prep the witnesses, right? I don't know if anybody's ever had to be a witness in a trial. A lot of you are cops or forensics investigators. People who haven't done it, they're scared, right? They are scared. They go up there.
Are scared.
Yeah, I remember one time, I had tried cases, but the first time I was a witness was for a student here. I should see that the other school I taught at. But that student had stabbed somebody and they called me to be a character witness for them. And I had to go to court. And then I had to walk in, and I was under that rule. I was out in the hallway. They called me in and I'm looking around with all these people and you see this Bible in front of me and say, oh, it was scary.
I was nervous every time I testified,
Isn't it?
as a crime scene technician.
And as a professional,
Yeah.
right?
Of course, your reputation, when you're doing it for your job,
your reputation is on the line.
Yes, yeah.
So it's a
Okay.
whole different level of being, you know.
Reputation, afraid they're gonna make a mistake,
Yeah.
afraid the judge is gonna put them in jail because they've seen these crazy judges on jail, you know, who do stuff like that sometimes.
And
So,
especially children,
oh, for sure, a
you know,
child,
teenagers, juveniles, yeah.
grown-ups, everybody. So you want to babysit your, I don't want to use that term. You want to sit with your witness, calm them down, make sure they know what to expect, refresh their recollection. Don't make it rehearse, right? But refresh their recollection so they know what they're doing. That's one of the things that they do.
And
Um,
Sharon, just to add what Laura had mentioned, in the Johnny had commented,
Mhm.
I was on trial and they automatically swore me in as an expert witness.
Oh,
And I mean, you're drilled on the stand and it's like taking a quiz of being an accident reconstructionist.
Yeah.
They went down as far as, can you explain this mathematical equation
Yeah,
that
and
you
that's,
came up with that?
that's a good point, Henry. That's a whole other level when you're sworn in as an expert witness. That's different. Crime scene technicians are generally not considered expert witnesses
And-
when they're just talking about crime
The reason
scene.
why,
But someone like an accident
the reason why I
reconstruction.
say that, this was
Yeah,
brought up out of the blue,
yeah.
doing the questioning.
like it just
And
came
the
up.
defense said, Your Honor, I would like to see if he qualifies as an expert witness.
Yeah.
Because his testimony now sounds like he's an expert witness.
Well, because the difference, what the difference is with an expert witness is they are allowed to give opinions.
yes.
Everyone else is just answering questions about what they observed and what they did at the scene, but expert witnesses give opinions. That's a whole other level of credibility.
Yeah, it's a whole
Yeah.
different thing to be
Yeah,
an
but
expert.
what was shocking about the whole thing is, I was just a regular person.
You didn't know it was
You didn't
coming.
know
I didn't know it was
Yeah.
coming. I got
Yeah.
blindsided. I didn't have a chance to prepare. I didn't have
Yeah.
any notes.
Yeah,
Oh, yeah, because he was trying to discredit me
Yeah.
immediately.
Of course, that's his job.
right.
Yeah.
That's his job, right? He's gonna make you look bad. That's what cross-exam is about. And experts, they usually have, you can have something called it's a mini voir dire, where they put the expert through their cases and decide, they could have asked you, well, what's your expertise based on, Mr. White, you know, and then you have to kind of pull it out of.
Right, that's
Well,
when they
you
go
know,
into your
Education.
average, your average police officer or crime scene tech. They might ask you a few questions, how long have you been with the department? Because you're just, but when you're like the coroner, medical examiner, or you're, you know, accident reconstructionist, DNA expert, any one of those people who is examining evidence and making a conclusion about it, then you're gonna be an expert witness, and they're gonna delve much deeper into your background and your training,
True.
how many times you've testified, what your qualifications are as an expert witness, and then, I mean, Johnny, and you, there, sometimes there's entire hearings for that,
Yeah,
just to
just to see who
qualify
the
you
expert is and what
as
the.
an expert.
It might end up being
Yeah.
3 days.
Yeah,
It'll be
exactly.
3 days.
Interesting.
And that, and again, it can be like the battle of the experts. Yeah,
Yeah, a lot of times it is. Insanity cases, if somebody pleads insanity,
exactly.
it's almost always a battle of the two psychiatrists. Each side's gonna have one, right? And it's a jury. This is interesting, because I heard people say, oh, we have the best system in the world.
Right.
It's a jury of people off the street who have to decide which of those very highly qualified people is more
And
credible. So,
Terry, if I
it can
can,
be
Terry,
different. Mhm.
Terry, if I can,
Yeah, proceed.
so, you know, I was qualified as an expert in narcotics and surveillance and a few other things. But over the years, and I was in there for a long time, you know, you get to know the defense attorneys. And so when I was introduced as an expert witness, they would stipulate that I was an expert because they did not want the jury to hear my qualifications and everything that I had done and the training that I had, because it places so much weight on my testimony where they could just
Right.
accept it as being great. So the defense attorney would say, well, we'll stipulate he's an expert and just move
Yep.
on.
That's a good strategy sometimes. Okay.
Yep.
So, yeah. So here we are, we're talking about the handling the witnesses, getting them ready, whether they're an expert or just an occurrence witness. The other kind of witness is a character witness. You can't really bring those in as a prosecutor unless the defendant, you say, opens the door with a good character witness. So what we have here on our side, you'd have the occurrence witnesses and the experts. You got to get them prepped. If sometimes there are litanies you can go through. If somebody forgets something, you want to have them know that you're going to ask them, was there anything else? And that's their cue to say, I don't recall. Not no, but I don't recall. And then you're going to ask them, is there anything that would help refresh their memory? And they're going to ask the Okay, and you can get it in. So if you prep them with little things like that, that'll help them come through. The last thing I say here, I've had witnesses say sometimes to me, well, what do you want me to say? And, you know, there's lots of leeway in how you say it, but the answer is always, I want you to tell the truth. Okay, you get in a lot of trouble for not telling the truth. So, you know, yeah, tell the truth and we'll work with you on how you can best get that across. Okay, so sometimes the paralegals do that. All right, so we did our witness testimony. We talked about some of our real evidence and what that's going to be. We also have this thing called demonstrative evidence. It's sort of like show and tell for the jury that will help the jury understand the scene. I don't know if anybody saw any of the what I call the George Floyd trial, their trial of Derek Chauvin. I watched some of it, and they had up there, they had a map, not unlike this one, not of the inside of the house, but of that shop, you know, where the fake 20 went on and all that stuff. And every witness that came up was basically asking for their testimony, can you show the jury where you are? You know, vis-a-vis the other players in this matter. So what we're going to use here as a prosecutors, we've got two things that I think will be really important when we try this case. One of them is this scene that we have of the murder scene, and we'll see when the police arrived, they couldn't get through the front door, they went around the back, they came in here through here into the utility room, and you'll see the first room they hit is the master bedroom where Colette's body was found. Okay, so they'll talk about that, and they'll talk about what they found in each room. The other thing you'll see here are these little A's and ABs and B's and O's. And what was kind of odd here, and a good break for the prosecution, was that of the 4 people in this house, they each had a different blood type. So you could see, let's see, Colette McDonald is A, Kimberly McDonald is AB, and you'll see here that part of the prosecution's theory is that Jeffrey McDonald and his wife, it's just a theory, they were having a fight in the master bedroom, and that little Kim came in and was like, Mommy, Daddy, no, right? And that Jeffrey accidentally whacked her with a club. They found a lot of blood from her there. They found a little bit of brain matter from her there, sorry to say. And you'll see here, this big pool that they have marked here of A and AB. And then it looks like, this is the prosecution's theory, that Jeffrey picked up his daughter and wrapped her in this sheet with AB and A blood, his Colette's blood and hers, and took her back to her own room. Okay. And what? Yeah, maybe put a doll by her, tucked her in. Certainly a hippie wouldn't do that. Might her father have done that? Yeah. If he hit her by accident? No. And he's like, oh my gosh, what did I do? He's a doctor. He knows he's crushed her skull. Like I said, it's a theory. Okay.
Maybe Helen Shanek.
What's that? I didn't hear.
Maybe Helen Shanek placed the doll. Helen, what is her name? Helen Shanek, the drug.
Oh, the drug lady,
the drug lady.
Oh, yeah. Yeah, I don't know. But yeah, with the doll tucked in, some of this is really strange. And some of his reactions are strange. And when we get to the defense, some of them might have been shock, post-traumatic shock, but some of them are really strange. And by giving a statement, he kind of hurt himself.
So Kimberly's blood is found throughout the hallway, the master bedroom, and then what is that? I see her, is that another area also?
This is her bedroom down in the front, above where it says blood type. So yeah, from the master bedroom through the hallway into her bed. Okay, and you'll see here in the bed there's AB and some others, mixture of A and AB. Colette, prosecution's theory is that she was down but not out, and that while he was taking the kids out, that she came in and threw her body over the children, tried to save them. Okay, again, it's just a theory, but you'll see her blood, Colette's blood, not only where she was hit and where her body was found, but over here in Kimberly's room. And where is the other little girl's room? I'm not sure. I think this is it. Yeah, Kristen is the baby. And you'll see her blood in here too, with Colette's. So we'll look at that in more detail tomorrow, okay? But for now, that would be the kind of a exhibit, right, that you definitely want to know what you were doing with and put up there in front of the jury so you can answer the questions better than I'm answering right now, okay? And it tells a story.
And Terry, is that chart, is it on the website? I mean,
oh yeah, there's all these exhibits are on the website.
Okay.
It's not one website, so it's multiple ones.
Yeah,
a lot of this stuff has been preserved. And what you would do with things like this, you want to know in advance whether this is going to be admitted or not, right? So there'd be a motion in limine beforehand, and the judge is gonna say, is this a good chart? Is this accurate? Remember Professor Miller yesterday was saying, you know, we can measure the rooms and make sure that it's accurate, not misleading, and the standard is, would it be helpful to the jury? It's pretty much in the discretion of the judge, okay? Very hard to get that overturned. Anytime something's in the discretion of the trial judge, good luck getting that through an appeal. So he did let that in, the judge let that in. The other thing that I think was a very good element of demonstrative evidence, this is not, well, I guess the pajama top is real evidence, but this thing here that looks like a dressmaker's doll, that's demonstrative. That's intended to help the jury. And it's a, you know, it's a Colette size dress, okay? And that thing, that blue thing on it, that is Jeffrey's pajama top, okay? That, I have to tell you this, he testified that when he woke up in the living room, right? The first time he saw his wife's body, her breasts were exposed, he says, I just took off my pajama top and I dropped it there. And I think that's a normal thing for a husband and a father to do, okay? He dropped it there, and then he went and checked on the kids. What he didn't explain is how come that pajama top has not just Colette's blood on it, but Kimmy's blood and Kristen's blood, and not a little bit, tons of it, okay? The other thing they saw when the prosecution worked with this pajama top, and it took a computer and an analyst like hours and hours and days of doing this, they found that they could match the holes in that pajama top made by the ice pick, right, with the holes in Colette's chest. So their theory, you guys know what the theory is? It took me a while to get. What are they saying? He put the pajama top on her chest first, and then whoever stabbed her did it later, right? So it's not like the intruders could have done it because the pajama top wouldn't have been there, right? It would have been on him when they were here. Who had to do that? Jeffrey, you know. So that becomes something that I don't know how convincing you find that. That was a key pin. It's, what is it? It's
So he said he had that shirt on, he took that shirt off and placed that shirt on her.
on his body,
And that shirt has holes from an ice pick,
23 holes
23 holes.
So
So
that's-
each child had 23 stab wounds.
at least. So not always 23. It wasn't like that. It wasn't like
I
a
was gonna
23.
say,
no,
like, why is it
23.
okay.
No, some had 32, some had 27. There were knives too, you know. It just was definitely overkill. But this is going to be a key point for the prosecution's case. And at one point, they would ask Jeffrey, do you have an explanation for that? And his answer is, of course not. Okay. On the other hand, it's not his burden, it's their burden to prove. You guys find that convincing?
Yeah.
It's quite the coincidence, isn't it? Laura doesn't like it.
It was quite the coincidence.
Quite the
Okay,
coincidence.
Is there, okay, can you go back to the, I know, sorry.
Mhm, it's okay.
So, can you
Which
go
one?
back to the diagram?
Yes.
Is his blood somewhere else and throughout? I see AB a lot,
What is he? He is B by itself.
right?
And what you're going to find is very little B blood at all. And that's because he wasn't hurt very badly.
So he
Yeah.
said he woke up, but he had wounds. So is he saying that the person woke him up stabbing him in the living room?
Yeah. Over here. And there's very little blood in the living room. This blood here where it says A or AB, they couldn't tell. That was actually a smear on the on a magazine. You know, there wasn't a lot there. You can see with the glass, there's a flower pot that someone stood up. But very little of his blood is anywhere. I'll just tell you, one of the places where his blood is in the bathroom, in the sink. And they're going to say the one wound he had, he gave to himself. If you're going to stab yourself, where would you go do it? Would you go to the bathroom where the light's good, right? Stand over the sink. And there's a step ladder in the bathroom too that has his blood on it. Help me find the bath. There it is. Step ladder in the bathroom back here. And there's B blood on the ladder and in the sink, not much B blood anywhere else. Here's a little bit, right? He was bleeding some. He did get, you know, some superficial wounds somewhere along the line, whether he gave them to himself or whether the intruders did it, who knows? This is interesting too. I just saw this. Oh, down here in the corner of the living room, they found his reading glasses. And his story was he fell asleep on the sofa, right? Put the glasses down, but the glasses had Kimmy's blood on them. How did that happen? How did her blood get on your glasses?
Yeah, if you fell asleep before they were killed.
Before they were killed, before anybody came in, but her blood happens to be on your reading glasses. Here again, I think I said this yesterday, a lot of the case against him is the story you told just doesn't, it doesn't sync up. Okay, so
Yeah. Do you know what his vision was?
no idea, no idea.
Because I know when I take my glasses off, I can't see.
You can't see. I don't know, John, I don't know. Okay,
Anyway.
so this, is there a way to make this bigger without losing it? Do you guys know? I don't know what I could do. All right, and, okay, so this is the next thing you do as a paralegal or as a lawyer. Look at strengths and weaknesses of your case, okay? Know what your strong points are, know what your weak points are. Focus your case on the strong points. Be ready on the weak points. Know that your witnesses are going to be cross-examined. And they're going to be asked this, that, and the other thing. So you want to prep them, not just on the testimony they're going to give, but on their weak points. One of the weak points here is that while coming to the initial call for help, while reporting to the 911 call, the officer who we're going to make the composite officer, he's driving his car, and what does he see on the street at 3 in the morning? With his lady, and she's wearing boots and a floppy hat, and she's got, it looks kind of weird to him. Weird enough that he called again and asked for backup. Nobody ever backed it up. And sure enough, when Dr. McDonald describes the intruders, one that he describes very clearly, there's a lady wearing boots and a floppy hat. She was seen about 11 minutes from the house if you were walking. Okay. So what are you going to do with that if you're the prosecutor? Do you want to put that out there in your own case? Or do you want to wait? Okay. Or do you want to wait? I'm running out of time here, but what do you think? Would it be better to let the jury know from your own officer this happened? Or do you want to wait till the defendant brings it up on a cross? What do you do with your weaknesses, in other words?
I would bring it up.
I would bring it up too. What do you think, Henry? Bring it up? Hide it? Wait for them to get it? What do they tell you to do? What's your mom tell you to do? If you did something wrong, admit it up front. That's what I would do,
Less damage.
So yeah, it's probably less damaging there. So the damages that we have, the damaging part of the prosecution's case are 1, this lady on the street corner. 2, the fact that if you were here with Professor Miller, the crime scene was messed up. The word trip through was used a lot. There were 25 people who walked through the house and messed up some stuff. And they lost some things. They lost the hair, they lost the PJ bottoms, they took the trash out the next day without checking it first. There were things that probably shouldn't have happened. But what we're going to say from the prosecution's point of view is even if you throw all that stuff out the window, we still got plenty. We still got plenty. That's our argument. Okay, so we're going to go through our case like that and prep our witnesses, prep them for both direct and cross. Okay, and down here, let's see, prosecution exhibits. Let me just show you these very quickly. Okay, I put the exhibits together in a way that I thought told a story. There's the family, there's the house, there's what you see when you walk through the door. There's Colette's body lying there. It doesn't look good. There's the close-up, too close. That's her pajama top. Now that could be an item of real evidence that would have, I think, a real impact on the jury to see a pajama top that's soaked in blood. This is a hairbrush. Part of the theory was that she might have whacked him with a hairbrush and he hit her back. This is the word pig scrawled in blood on the headboard. It's hard to see, but it's P-I-G in blood, a lot like the Manson murders. We've got gloves, we've got the kids. There's the kids' nightgowns. Just so your jury, this is what I would show the jury as we go through. Here's what happened. When they went outside, they found the knife and I think the ice pick lying on the ground. And then we can show, and if it were really a case, we could actually show these weapons. Since we're in a school, we're going to show pictures of the weapons. Okay, this ice pick, the club, and the knives that were used. This is the living room. What does it look like to you guys? Does it look like there was a struggle for a guy's life in there with 4 people?
Yeah.
What does it look like? Yeah, well, he turned the coffee table upside. Okay, they're gonna say.
The lamp should have been on.
You think? Okay. One of the investigators says he has, his living room looks worse when he's done fighting with his dog than after this. So then we got the little bit of blood that they took from the sink and typed to be his. That's his blood spatter in the sink. These were his wounds. This is interesting. This is what the emergency doctor noticed about his wounds. And you can see there at the top, it says he has a bruise on his head, but it did not break the skin, 4 tiny marks. And at the bottom there's something that went between his ribs, a knife that went between his ribs. That one could have killed him, but it didn't because it was placed within an inch, wasn't placed close enough. And people say, well, you did that to yourself. He says, nope. Okay, that's his pajama top with the holes marked. We've seen this one before. This is the sketch. He was able, now this is kind of interesting. He was able to give some very good, I think pretty good, don't you think? Is that good? Specific descriptions of the people who had attacked him, including the lady in the white hat. The thing is that there were gangs of people, he might have seen these people, you know. Helena Stokely in particular was the daughter of a captain on the base. She was known, she was a police informant, but he gave those descriptions. And the prosecutor's going to say, and it's not like we didn't take you seriously, we did. You know, this is the newspaper the next day. We are looking for the ritualistic murders. Okay, so they bought it. And then as they started looking at the forensic evidence, they thought, we don't think this is what happened. Okay, so that's just an overview. I don't know that I'm going to be able to go through the rest of this. Okay, so that's an overview of the prosecutor's case as they go through it. Sure, anybody got any questions? Absolutely.
I just see a number in the chat. So
I don't see
at the top.
the chat. Okay, just two. Okay, let me see. It just says, please put questions in the chat. Maybe bring it up to prevent distrust. That was from Arthur Cook, and I think that was with regard to whether you would want to reveal your weak places, your weak points yourself. So yeah, I think you probably would want to do that. Okay, let me see if I can go back to this a little bit. Cross-exam, okay. When you cross-examine the witnesses for the other side, and we're the prosecutor here, so we're talking about the defense witnesses. This is what they taught me in law school. I think this is probably what they taught John too. There was a guy named Irving Younger who did this 10 commandments of cross-exam. And you'll see cross-exam by definition, the witness is not helping you, right? They're on the other side. Be brief, be short, lead them where you want them to go. I always touch my nose because I think of the owl and the pussycat and the ring through the end of the piggy's nose. Take them where you want them to admit. And this is important. Don't get into a fight with the witness. It doesn't look good and the witness is going to win, okay? Just make the points you need to ask and sit down. And then the argument goes to the jury at the end about how the witness's testimony wasn't good. So if you were to open this folder that I'm going to skip, there are some points here for cross of the defense witnesses who we know they're going to be.
Never ask a question to which you don't know.
Never ask a question which you don't know the answer. It's just, it's considered
should be
too
number one.
risky. Yeah, yeah, that's up there too. So those are some of the things that you would watch out for as you prep your witnesses for cross. Other issues that I thought were interesting in this case. One is the hearsay rule, because we're going to have, you know, Helena, this is Helena, by the way, okay? We're going to have some people talk about, she's dead. She's dead by the time this is, our trial's happening. So we're going to have some statements that she gave to people. And, you know,
Terry, I have a question in the chat
yeah.
from Arthur Cook. Would
Yeah.
a good defendant try to throw away weak evidence if the prosecutor presents it, or should you try to prove it wrong?
Would a good defendant try to, I'm sorry.
Throw away weak evidence
Yeah.
if the prosecutor presents it, or should you try and just prove it wrong?
I'm not real sure how I'd answer that. I think generally you're best off sticking to your own theory of the case and not getting too distracted by what the other side might have, especially if it's not a big bomb, you know? So I would probably not let it derail my case. I would probably mention it in the closing and try to discredit it if I could. I hope that's a reasonable answer. Not sure I understand the question. But remember that you have the burden of proof if you're the prosecutor. The defendant doesn't have to prove anything. And that also is going to feed into the extent to which they get led down a path that you don't choose. But stick with your case. That's what I would do, at least during that evidence proportions. We're going to have some hearsay coming in, some dead people testifying in this class, which is unusual, but not impossible. John talked about the jury. It's interesting. Think about who you want on your jury. If you're Jeff, do you want a jury in the first place? The general, not necessarily. Yeah, I mean, you slaughter these kids. The jury's going to look at these pictures and they're going to go, ew, right?
I want to take your chances with the judge.
You can roll your dice with the judge if you want to. The thing about the jury is when there's just circumstantial evidence, the plus with the jury is you got 12 minds, right, that you got to work with. So there's it's a decision for him to make, okay? And the ethical standards, just real quickly. This is an image that I use a lot in my classes. Our legal system is kind of like, it's called the adversarial system. What did I do? And you see these two people jousting. That kind of is the way that it kind of Looks like sometimes, if you are Jeff, if you are the defense attorney, you're his knight in shining armor. You're trying to get him off, right? If you're the prosecutor, you're up there and you're representing the United States, you're actually supposed to do justice. Okay, you're not supposed to cheat. You're not supposed to lie. If you find, as they found in this case, some evidence that supported his story, you got to turn it over. It's something called the Brady rule. So we'll talk about that. They found a hair in the house that matched or could match the wig that he said the lady was wearing. And they found some little hair under that one of the daughter's fingernails. That stuff is what's called Brady material. Should have been turned over. And we will have it in the trial we're doing. It'll be turned over. We'll see what the jury thinks of it. Open and close, John covered. The role of the paralegal at trial, I really think it's keeping everybody calm. You know, just sitting there, keeping everybody calm and organized. Especially your defendant, especially somebody like Jeff, who carried himself as arrogant and turned the jury. You just want to keep him calm. You know, take him outside if he needs to kick something, you know, so he doesn't do it in front of the jury. I think that's a good one. And you have this notebook. You make sure that your attorney asks the questions they intended to ask. They don't miss anything. Okay. And that'll get you through. That's what the paralegal gets to do. These are the attorneys. I just put you might recognize them. That's Marsha Clark and Chris Darden. Looking not so great, you know, as the OJ case is falling apart around them. Maybe they needed good paralegals. Trials are very, very stressful. If you're involved in one, I would suggest talking with your loved ones at home and letting them know that you're not going to be there for a couple of weeks, and anything they can do to cover for you with regard to your kids or your meals or whatever is great. If you're lucky enough to work, as I did sometimes for a big firm, you can build a client for meals, right, or hotel bills and stuff like that. But just be aware, it's just a very, very stressful time in your life. Okay, maybe any questions? No? No, thank you. Okay, so come tomorrow. Please come
Well,
tomorrow.
we want to give a round of applause to Professor Blyer for her presentation today. Thank you so much, Terry. And thank you all for joining us today. And please do come back tomorrow for our trial. We need to do some role playing tomorrow.
Yes.
You can come over here. For those of you online, you can come to the continuing education building on the first floor. And we're going to assign you a role and you can take part in our mock trial tomorrow. So thank you for joining us, everybody.
Thank you.
Good job. Good
Thank
job.
you. Thank you.
See you tomorrow. You know, tomorrow. We may ourselves.
Right.